Does the wearing of the hijab or the headscarf constitute a fundamental right under the Constitution? Is the wearing of the hijab an essential religious practice? These two questions are being considered by the Karnataka High Court, which is hearing a batch of petitions filed by Muslim students challenging the hijab ban in their colleges. So how do courts go about deciding what is an essential religious practice? And what have courts said on the hijab so far? Let me explain. But first, I just want to quickly remind you that the Newsminute has been covering this story very closely, both from the ground and from the court. We cannot do stories like this which take time, effort and resources without your support. So do become a member of the Newsminute today. We have two types of membership starting at 1,179 rupees for a full year. Also, to catch every episode of Let Me Explain, which comes out every week, do subscribe to our YouTube channel. Before I go into the legal aspects, I just want to quickly recap the hijab row for you. In December last year, 8 girls belonging to the Women's Government Pre-University College in Udupi were barred from class for wearing the hijab. Now, the college principal cites uniformity as the reason. But the girls say that wearing the hijab is a part of their faith and it is their right to wear it. On January 31st, these girls went to the Karnataka High Court challenging this hijab ban. Then on February 3rd, over 20 Muslim students belonging to the Kundapur Government Pre-University College were also barred from class for wearing the hijab. Now, some of these students too have approached the Karnataka High Court over the issue. The girls say that wearing the hijab is their fundamental right as guaranteed under Article 25 of the Constitution. Article 25 is the right to freely profess, practice and propagate religion. But the state can impose restrictions on these freedoms on certain grounds, including maintaining public order. Okay, like I mentioned earlier, there are two questions before the court. 1. Does the wearing of the hijab constitute a fundamental right under Article 25? And 2. Is the wearing of the hijab an essential religious practice? Now, it is the second question that will have to be answered first, because the Supreme Court has held that only essential religious practices are protected under Article 25. So how do courts decide what is an essential religious practice? Way back in 1954, the Supreme Court had held in the Shirur Mat case that what constitutes the essential part of a religion is primarily to be ascertained by the doctrines of that religion itself. To put it very simply, the Supreme Court basically said that use the religious text of that religion to decide whether something is essential or not. This landmark judgment by the Supreme Court has since become a test to decide if something is essential or integral to the religion and can therefore be protected under the Constitution. Let's look at some cases where this test has been applied. In 1983, the Anand Marg sect went to the Supreme Court after the Calcutta police refused to allow them to perform the Tandava dance in public. Now, the Supreme Court applied the test and found that the Tandava dance, which is performed using a knife, a live snake, a skull, or a trident, is not an essential religious practice to the Anand Marg. Now, there have been controversial judgments where this principle has been applied, like in the 1994 Ismail Farooqi case, where the Union government's acquisition of land in and around the Babri Masjid in Ayodhya was challenged. A 5-judge bench of the Supreme Court had found that the mosque is not an essential part of Islam because namaz could be offered anywhere. The test was more recently applied in the 2018 Sabarimala judgment, where the majority held that barring women of menstruating age was not an essential part of the religion. Now, as far as the hijab is specifically concerned, over the years, various courts have determined whether it is an essential part of Islam. Let's look at 4 cases where Muslim girl students have challenged the hijab ban and how courts have dealt with them. 1. In 2016, the Kerala High Court found that covering the head is an essential part of Islam. The court was hearing a petition filed by a Muslim girl student challenging the CBSE's dress code for the All India Pre-Medical Entrance Test. The CBSE had come up with a dress code to prevent cheating, but the petitioner argued that banning the hijab and full sleeves violates Article 25. The High Court eventually ruled in favor of the petitioner, but also asked girls in hijab and full sleeves to appear 1 hour before the exam for a frisking. 2. The Kerala High Court had just a year earlier come up with a similar ruling in the Nida Rahim case. The court had allowed Muslim girls to wear the hijab and full sleeves in the All India Pre-Medical Test. Here too, girls were asked to come at least half an hour in advance of the exam for a frisking. Justice Vinod Chandran in his judgment said that in a country as diverse as India, authorities cannot insist that a particular dress as mandated by religion be avoided while writing an exam. 3. This is another Kerala High Court judgment and it came in 2018. A Muslim man approached the High Court after a private Christian institution where his 2 minor daughters were studying did not allow the headscarf. But in this case, the Kerala High Court ruled in favor of the private school, arguing that it had an equal fundamental right to manage and administer an institution. In such cases of competing rights, the court ruled that the larger interest of the institution must prevail over individual rights. Incidentally, it's the same judge, Justice Mustaq, who had in 2016 found that the hijab is an essential religious practice. This Kerala High Court judgment has been cited by the Karnataka government in its order on February 5th to argue that the ban on hijab does not violate Article 25. Advocates Sanjay Hegde and Devdutt Kamath, who are appearing for the Muslim girls, said in court that this Kerala High Court judgment cannot be considered a precedent. This is because that in the Kerala case, the school is a private minority institution and not a government one. In India, minority institutions enjoy certain rights under Article 30 of the Constitution. 4. In 2003, the Bombay High Court had ruled in favor of an all-girls school which did not allow the hijab. The High Court said that the Quran does not mandate the wearing of hijab in front of other women. The Karnataka government has cited this judgment too in its order. But Advocate Kamath, while appearing in court, said that this judgment too is not a valid precedent because in the Bombay High Court case, the school is an all-girls one, whereas in Kundapur it is co-ed. There are of course other judgments that the High Court will consider before it pronounces its verdict. What's certain is that whichever way this goes, the present case in the Karnataka High Court will have far-reaching consequences for the rights of Muslim girls and women in India. Remember, if you've liked this video, don't forget to hit the like button and share this video with your friends.